As you know, the title of this class is, you mean contracts have to be in writing? You know, and that's kind of a silly name for the class, but you would be so surprised how often we get calls from members who don't quite grasp that concept, that a real estate contract in Texas, yes, it must be in writing. So, what does that come from? What is that based upon? All right, the first thing we're going to talk about is the statute of frauds, which is the very source of that rule. You have there in your packet the statute of frauds. This isn't just some, random arbitrary concept. This is an actual statute from the Texas Business and Commerce Code. If you'll look there in 26.01 subsection B, if you look at number 4, you'll see that that section applies to a contract for the sale of real estate. All right, so any contract for the sale of real estate in this state must be in writing. But not just that. If you look at number 6, you'll see that not just sales of real estate, any lease agreement for a term of longer than a year must be in writing. Okay, so what does that mean also? If a lease is less than a year, it can be oral. That's sometimes surprising to people, but if there's a lease that's for less than a term of a year, it can be oral. So you want to be careful about that, because you don't want to have a lease held against you because you didn't get something in writing. All right? Okay. So let's move on from the statute of frauds and just talk about some contract definitions. Can anybody tell me the elements of contract formation? What would be one of the elements of contract formation? Parties, okay, yeah, you've got to have 2 parties, but that's not going to be one of the elements, really. Mutual agreement, that's a good one. That's a good consideration. Sure. Date, money, all right. Well, let's just kind of talk about what those elements are. Okay, first you've got to have an offer. You've got to have an offer and you've got to have acceptance. So you've got to have a writing, okay? You've got to have agreement upon the material terms of the contract. You've got to have signature of both parties, and you've got to have the communication of final acceptance back to the original offeror. Okay, so once you've got all of those elements of contract formation, you've got a contract. Now here in your packet, you've got the definition of all of the little contractual type terms. What is a contract? It's a promise or a set of promises for breach of which the law gives a remedy. All right, or the performance of which the law in some way recognizes a duty. Is that an offer? A lot of times people will say, we've got a contract in the office today. Well, they're really referring to what? An offer. Okay, so be careful when you're talking about that. You want to always use the correct terminology so that you don't confuse people. All right, an offer is basically just something that creates the power of acceptance in somebody else. So if you receive a written document from a buyer with their signature on it, making an offer on a property, and it's got their signature on it, then if it creates an actual power of acceptance in the seller, such that if the seller were just to sign it and say, I accept, that would have been an offer. All right? But if it's just some document that they've given you with terms that still requires 2 signatures, then it's not really an offer. It's just kind of communication. All right. Let's go through one of the other ones. Talk about rejection. One of the things that we talk about when Avis and I teach this class is how you want to go about actually rejecting an offer if you've received an offer into your office. All right, so buyer has submitted an offer and the seller doesn't really want to proceed with that. What does the seller need to do? Okay, how should the seller respond such that they are effectively rejecting an offer? Okay. Oh, okay. Okay, oh, you're talking about the seller's invitation to submit a new offer. Okay, that would be a great mechanism to reject an offer. Okay, we do have that form. You've got it in your packet. Okay. I think it may even be, it's the next page. Should be. All right, the seller's invitation to buyer to submit new offer. Okay, so if the seller receives an offer, they don't want to go forward with it, the seller can just simply send back that form, seller's invitation to buyer to submit new offer, And that would be an effective rejection of an offer. But you don't necessarily have to use that form to reject an offer. A seller can call up a buyer and say, you reject. Or a listing broker can call up a cooperating broker and say, you know, my seller's rejecting that offer. That would be an effective rejection. All right?
That would nothing.
I'm sorry?
If you do nothing, is that a rejection?
If you do nothing, not necessarily it's not a rejection, no, because unless there's some action that's taken, you know, offers can just kind of hang out there. And that is a good question, because we often hear, how long is an offer effective? How long can an offer be, you know, be hanging out there without some action being taken on it? And there's no real actual answer to that. It's kind of a gray area, but we kind of say, what we tend to say is, it's been several weeks. If it's been a month later, a seller's probably not going to be able to just sign an offer now and say, oh, I accept your offer from a month ago. That's getting a little bit too long. Yes, another question.
Usually when you write an offer, though, don't put time limitations
Repeat the question.
or response sometimes.
Okay, the question is, when you when a buyer submits an offer on a property, or when an offer is submitted, let me just say that, isn't there usually a time that is submitted as well, so that the seller, so that the offeree has a certain amount of time to respond? And the answer to that is yes, sometimes. Sometimes offers are submitted without the offeror indicating a certain amount of time. And so in that situation, you do have that problem where an offer could just be sitting out there. But sometimes you do have people who submit offers with a specific time, and that's actually a great mechanism to kind of make sure you're kind of capping that time. When you do submit an offer like that, where you've got a specified amount of time for which an acceptance can be conveyed, you do want to make sure you're putting all of the appropriate language in there. So, you know, as Avis is saying, you want to say, seller has until 5 p.m. on April 5th to respond to this offer, or the offer will expire. You could just say that. Even that would be effective. But you do want to say, or what. Okay? What about revocation? So let's say that you're a buyer, or representing a buyer, and the buyer wants to revoke that offer. What do you have to do to revoke an offer? How can an effective revocation occur? Okay? Her thought was that you would submit a termination of contract to revoke an offer. Okay, and that would actually probably not be the best way to do that, because what do we have on the table right now? An offer, not a contract, okay? Any other thoughts about how to revoke an offer? Okay, her thought is that you would just communicate to the person who the offer was made to that the offer has been revoked. And that's exactly what you would need to do. Now that communication can, you know, theoretically be verbal. You know, the buyer's agent can call up the listing broker and say, my buyer is revoking their offer. But you will always run into a proof issue, okay? It can be oral. So oral revocation would be effective, but so you need to follow that up with something. I always tell people, you know, call the listing broker up immediately when your buyer wants to revoke, and let them know, because as soon as they accept, you can no longer revoke. So you want to call them up immediately. Tell the listing broker that my client is revoking their offer. I'll be sending you an email as soon as we hang up, or sending you a fax or something, so that you have some sort of documentation of that oral communication of revocation. And Avis made a great point that you want to have a time and date stamp on that documentation of the revocation. Okay, that's a great question. Her question is, doesn't the seller have to communicate acceptance of an offer prior to the contract being created? And the answer is yes. I mean, the seller can sign a contract, but if they have not communicated back to the buyer that acceptance or that signature, then you're right, there would not be any contract. So, you know, even if the seller has signed but they haven't communicated back that signature, then the buyer can still revoke. And the question was, does that work both ways? Does it work for the seller in case the seller has made an offer? And that's right. I mean, all of these scenarios work both ways. I'm using buyer as the offeror and seller as the offeree in my examples, because from my legal theoretical view, I tend to believe that the seller should always be the last person to accept a contract
And to sign it.
and to sign it. Do you have any thoughts about that from a practical perspective?
Agree.
Okay.